Good afternoon. This is Sean Golding with Golding and Golding. Continuing our 2025 update, we're going to focus on Form 3520. But for purposes of this presentation, we're just going to focus on large gifts and inheritance. You may also have to file Form 3520 and Sister Form 3520A, as in Adam, if you have ownership of a foreign trust or you receive foreign trust distributions. When do you file Form 3520? Well, let's start with receiving gifts from an individual. So Form 3520, for this purpose, is when a U.S. person receives a gift or foreign inheritance from a non-resident alien, and the value of the gift exceeds $100,000 in the year. Now, there's two main things to keep in mind, two nuances to consider. One, it doesn't have to be $100,000 in the gift. So, for example, it could be one gift of $600,000, you report that. Or it could be 12 gifts of $10,000 because your sweet mom helps offset your expenses while you're studying hard in school. Okay? Even though in the second situation, not one individual gift is above $100,000, the total value from one person in the year exceeds $100,000. So both of those are reportable. There's also the issue of related persons, related parties. So the IRS wants to prevent gift splitting to avoid reporting. So let's say, for example, your parents, right? One gives you $50,000, one gives you $75,000. Neither gift is above $100,000, but they're related, and the total value of gifts from related persons in the year exceeds $100,000. So guess what? You still have to file the form. With entities, it varies, it adjusts for inflation. So that $100,000 has been the same for a while. That threshold, it doesn't really vary much. With the entities, it adjusts for inflation. It's around $21,000, $22,000, depending on when you're listening to the presentation. Same rules apply. Sister corporations, sister entities, you still have to report Form 3520 if there's two corporations, let's say, and to avoid gift splitting rules, the IRS says, hey, one gave you $15,000, one gave you $10,000, combined value of $25,000, you still have to report. Now, when it comes to reporting the foreign gifts, there is some distinction when you have to file a gift from an individual versus when you have to file from an entity. When the gift is from an individual, other than having to file page 1, which you have to do for both, page 5 or 6 of Form 3520 is pretty straightforward. You just have to put the date, what the gift was, and the amount. So on January 10th, 2025, your non-resident alien mom gave you a gift, and that amount is $300,000. That's reportable. That's all you have to report. The entity, there is a little more detail, name of the entity, of course, address and things like that. So it's a little more intrusive. Why? Because the IRS wants to be able to look in, see if they have an ITIN or anything equivalent. They want to make sure that it's an actual gift and it is not a constructive dividend, right? Because, which is basically, it's a dividend pretending to be a gift, right? Because with a gift, there's no tax, right? There's no income that you have to pay. But with a constructive dividend, that's taxable income. So the real big issue when it comes to Form 3520 is the penalties. Now, with Form 3520, oftentimes the IRS likes to automatically assess penalties. What does that mean? That means when you file the form late, and assuming it's more than 5 months late, because typically people don't learn about it for a year or 2 or 3 or 5 after it was due, you pay a 25% penalty. It's automatically assessed. So Jane received a gift of $600,000 in 2021. Jane only learned about reporting in 2025. She files it and she gets automatic penalties of $150,000. So and that's ridiculous, right? It's absolutely absurd. And so in October, I believe, of 2024, the commissioner at the time said, hey, there was a UCLA conference and the commissioner said, we're not going to, this isn't right. We're going to stop doing this, right? Which sounds great, but now that commissioner is not there anymore. So there's nothing formalized that's happened yet in order to avoid automatic assessed penalties, or at least at the moment that we're recording this. Hopefully it'll come soon. So something to keep in mind, if you have unreported Form 3520 all over online, you'll see that the IRS said that they're going to stop with this automatic assessed penalty, but there's nothing technically that's happened yet. So when it comes to filing a late Form 3520, there's a few different options you have. If you have unreported foreign accounts, assets, investments, income, things like that, you may be able to include Form 3520 as part of your streamlined disclosure. There's pros and cons to that approach. You may be able to do delinquency procedures, but since it's not delinquent FBAR, instead it's delinquent international information return submission procedures, DIIRSP. Since November 2020, the IRS has become less inclined to grant an automatic penalty waiver. They used to grant the penalty waiver like they do for a delinquent FBAR, but they don't always do that now. So the other option is delinquency procedures or reasonable cause. In order to prove delinquency, in order to obtain a penalty waiver with delinquency procedures, you have to show reasonable cause. Otherwise, if you've already been penalized, you've gotten a CP15 notice, then you do the protest and the appeal, and you have to show reasonable cause as well. We have a ton of free information available on our main website and our sub-websites. You can always reach out and schedule a reduced fee initial consultation if it's appropriate to your matter, and it's something that we handle here. Again, my name is Sean Golding with Golding & Golding. Thank you for your time. Enjoy the rest of your day.